Was I left an inheritance? Hi, I'm Darren Findling of the Probate Pro, and we get calls from individuals who are wondering if they're included in the inheritance of the person that died. Now, this can occur in a variety of ways. Maybe they were named as a beneficiary on a bank account or a life insurance policy. Maybe they were named in a will or a trust. Maybe there were joint assets. The problem is that there's no one location that you go to identify how things are owned. It's not like a credit report exists itemizing all of the assets of the person that died. So there's a little bit of detective work that you have to do. The most logical place to look is in the person's important papers. After you've done that, then monitoring the mail and email is a great way to identify the existence of any assets, because renewal notices and statements will come in the mail. Of course, if a probate estate is opened, a probate estate is public record. It's filed in the probate court, and the people that are named in the will, what we call the devisees, and the heirs, which are the family members, are provided notice of the commencement of the probate estate. The inventory, which is a description of the assets within the probate estate, is public record if it's filed, but it may also be presented. If it is, the people that are interested in the affairs of the estate, the devisees, as well as the heirs at law, are entitled to review the inventory. That will let you know if you're going to be receiving an inheritance out of a probate estate. Well, what about a trust? Most trusts are not administered under the jurisdiction of the probate court. It's actually administered privately, and the contents of the trust, as well as the inventory, are not public record. If you are a named beneficiary in a trust, you are entitled to the relevant provisions of the trust to make you aware of your rights, and you're entitled to understand the assets that are going to be distributed out of the trust as a beneficiary. You're entitled to that information. The trustee just doesn't get to control all of the affairs of the trust without letting the people know. It's part of their fiduciary responsibilities to let the trust beneficiaries be aware of their right to inherit, as well as the assets that will be distributed. Now, if you're going to go on a detective sleuth mission to try to identify through various banks and financial institutions the existence of assets, it's sometimes difficult to do without a probate letter of authority. So first, we recommend that you go to various banking institutions that you believe that the individual may have banked with. Contact them and just simply say, here's a death certificate, this person died, I'd like to know if I'm a named beneficiary, and usually they'll let you know if there's an existence of an account or if you're a named beneficiary to provide you with the claim form. You can also contact the person's employment. Many large employers have benefits departments that will let you know the litany of available assets or beneficiary designated assets like life insurance policies that you should contact to file claims with. In addition, there's the unclaimed property division at the state of Michigan, or in individual states in which assets that have laid dormant go back, we call this escheating, to the state and are held in an account pending somebody coming forward to provide proof that they're entitled to the assets. So again, there's no one space, no one place to identify the existence of assets. Now, if you have a letter of authority from the probate court, you can take the death certificate and letters of authority, again, to each institution that you believe may be holding assets to at least discover the historical ownership of the assets. You can go to the Register of Deeds, of course, with or without the letters of authority to identify title and ownership. So again, these are some very practical pieces of information to help you uncover whether you're going to be receiving an inheritance. Now, sometimes we get calls from people who indicate that they are aware of the existence of a will. They strongly believe that they are the beneficiary or devotee within that will, but the person who is in control of the will, or maybe the trust, are not advancing the affairs of it by going to the probate court or advancing it through a trust administration. Now, the forum to resolve these types of issues is the probate court. It has jurisdiction of the administration of a will and, in certain circumstances, the administration of a trust. So you can go forth to the probate court and ask the court to intervene by opening up a deceased probate estate, and then ask for the person that is in control of the will to bring forth the will, which is a requirement under state law to bring forth the will for filing after the death of the individual. Now, these types of affairs can be quite confusing, frustrating, really emotionally exhausting. We strongly urge you to work with a skilled, competent probate practitioner to help you navigate through these complicated problems. If you have further questions about this issue or any probate-related issue, visit us at the Probate Pro, contact us at 1-833-PROBATE, or visit us at theprobatepro.com.